Hi, good afternoon, everyone. My name is Patrick. I hope you have a good lunch because I did, and I'm feeling quite sleepy. I hope that you will be awake because this is going to be a dry subject, unfortunately. But the good thing is that this is the first time I'm sharing this information publicly. In fact, this is the first time I actually created this topic for this seminar. Okay, in my previous seminars and my courses and all this, I've never done something like this. Okay, I hope that you can stay awake and bear with me for the next half an hour while I share with you information related to owning a property with using different structures. Okay, I'm going to bring you back to Singapore. Just now this morning we heard about investment in USA, Iskandar, and Australia. What I'm going to share with you in the next half an hour relates to mostly back home. In Singapore, I would say, because I'm not qualified to advise on the laws overseas. So it's going to be very much focused on Singapore. But having said that, I believe this is going to be very important, okay, especially for those who own property in Singapore. We're going to talk about a lot of things. We're going to talk a bit about inheritance law, how your property can be given away upon your death, or whether that's even possible. So it's one thing to know about buying, making money and all this, right? But if you don't know how to plan or knowing who to give or how to save on your stamp duties, then that may not be complete in my view. So I'm going to talk a bit about inheritance. I'm going to talk a bit about trust. I'm going to talk a bit about how you protect your asset, your real estate. I'm also going to share a bit on taxes, other than stamp duties. Using different structures, owning a piece of real estate in Singapore, and I believe in other countries as well, will have different tax implications. So it's going to be fairly ambitious. I hope that I can cram all this in within the next half an hour. Like I said, if you have any burning questions, please write it down. There will be a Q&A session later. I'll try my best to answer the questions later. Okay? Objectives of this afternoon seminar. At the end of this half an hour, I would have achieved my objectives if you have acquired a basic understanding of the different ways in which a property can be owned and to understand the implications of different property holding structures. Okay? Contrary to what you may know, I know most people buy property using their own name, right? Or the names of their spouse and themselves, or brothers and sisters, so on and so forth. But there are other kind of structures that you can consider using in buying a property, all right? And also to apply the appropriate property holding structures for your investments. Generally speaking, these are the few types of holding structures that you can use to own real estate in Singapore. Personal ownership, something that I think many people will know or many people have used. Ownership through business entities. What do I mean by business entities? Sole proprietorship, partnership, LLP, company limited by shares, company limited by guarantee, so on and so forth. Unincorporated associations such as your sports clubs, your societies. Trust, something very dry, something very technical, but it is very important and very sexy, okay, if you know how to use it. And other structures that you can consider using. Okay, so this segment is not so much about teaching you how to make money and where are the hot spots, but it's to give you a bit of an information overload that hopefully, after this half an hour, it won't work out, too much already, all right? Personal ownership. Okay, I have actually come up with this table. It's quite neat, I feel. When I created it, I thought, hey, that's quite neat, wow, this one very good info. One look only, all the different comparison. It's very nice. So you have sole ownership, you have joint ownership. Okay? Sole ownership means you own the property yourself. Or you go Iskandar, you buy one condo yourself. Very straightforward, right? You see your name on the title deed, you see your name on the SMP, you own the property, right? And then you have joint ownership, 2 or more, with your spouse, with your friend, with an investor, so on and so forth. 2 or more owners. As far as Singapore is concerned, the stamp duty implications, so of course when you buy a piece of property, you need to pay basic stamp duty of 3%, right? 3% of the value of the sale and purchase price minus 5,004, that will be the basic stamp duty that you need to pay, whether it's HDB, condo, or bungalow, all right? But if you are a Singapore citizen and you own the second property onwards, you are looking at ABSD of 7% more, okay? Or 10% if you own the third property onwards, all right? If you are a PR, straight away, 10%. So 3 plus 10, 13%. If you are a foreigner, you pay how much? 3 plus 15, right? 18%, okay? This is our latest cooling measures that the government has imposed. So different ownership. For personal ownership, these are the stamp duties that you're looking at. Buyer stamp duty and ABSD. And also SSD, 161284. So from the 5th year onward that you sell, you do not have to pay seller stamp duties. So if you're buying it on your own, or if you're buying it with somebody else, these are the stamp duties implications. I believe that is straightforward. Disposition by death. Okay, this is something maybe you will be interested to know. If you buy in your name, okay, if you have a condominium or even a HDB flat in Singapore in your own name, you may choose to give away that property in your will. Okay, in your will, you can say that I give my condominium to my brother or to Patrick. No problem, right? The law has to respect that. That's how important your will is. And that's why I've shared on many occasions that if you do not have a will, please do it. Because we are going to die. Question is when and how, in what shape and fashion, right? So I have shared with many people, you can buy properties, you can buy shares, you can buy a lot of things, but it's a pity that you don't have a will, which is probably the cheapest thing that you can buy, right? To tell your next of kin, your loved ones, that all my investments, if something were to happen to me, who is it going to go to, all right? So if you have a property in your sole name, you can say that when I die, I give this property to so and so. However, if you own this property in 2 or more names, and you own it in joint tenancy, okay? 2 or more names, there are 2 types, joint tenancy and tenancy in common. Go back and check your title deeds. For HDB, you check your duplicate lease. These magic words will be there. Joint tenancy or tenancy in common. If you have bought it in joint tenancy, means that when you die, you no longer own that property. Of course, you are dead already. But basically what it means is that the surviving joint owner becomes the sole owner of the property. What the survivor needs to do is to bring your death certificate, go to HDB at Toa Payoh, or file a notice of death with the Singapore Land Authority to inform them that my so-and-so has died. What they will do is that, okay, now you are the sole owner. That also means that the deceased owner cannot will away what he does not have. Because when he dies, he no longer owns the property, regardless of how much you pump in, how much you have invested in that property. So take note. So before you jump in and say, I want to buy this, I want to buy that, with my friend, with my brother, with my sister, think about the ownership. Or do you want it to say, okay, let's be fair. Since we put in the money equally, right, let's take tenancy in common 50-50, or 60-40, or 70-30. Because if you do that, your share will be preserved. When you die, you can include your share and give it away using your will. If you buy it in joint tenancy, and if you die first, finish. So don't die first. But it's hard to predict, isn't it, nowadays? Last year, depending on which plane you sit on, right? This kind of thing. So moral of the story, continue the plane story, right? From Siva. So moral of the story, before you make that kind of investment, you have to think through things like this. I put in how much? Do I want to buy in tenancy in common or joint tenancy? Because it will have implications upon your death, all right? Straightforward, huh? Ownership through business entities. Quickly, now we jump into the next structure. Company Private Limited and LLP. We have such thing called LLP in Singapore. It's like a hybrid, that you actually enjoy some sort of a limited liability, but at the same time, you don't have to file all the tedious annual returns, just like a private limited, right? So you can buy a property using this. A company private limited, that means a limited liability, or using an LLP. These entities are capable of owning property in its name, in their own name. So Patrick Tan Private Limited can actually own a condominium in Singapore. But would Patrick Tan Private Limited do that nowadays? Chances are probably not, because I would not want to pay 18% stamp duty. Right? The ABSD, the current ABSD say that if you use a company to buy a residential property in Singapore, you are subjected to 15% ABSD. So I may not want to do that, all right? Similarly, you can also use an LLP to own a property in Singapore. However, if you decide to register a sole proprietorship or a general partnership, you cannot own property in the firm's name, okay? Because they are not considered in law to be separate from you. So moral of the story is that if you want the entity to own the property, you have to incorporate a company or at least an LLP. If you do it by way of a sole proprietorship or a general partnership, the law would not regard you or regard the entity to own the property. And that will have different implications. Okay, and I will come to that later on. Company versus LLP. Tax implications. For company, income is taxed on the prevailing corporate tax rate. Currently, it stands at 17%. So if you can overcome the 18% ABSD and say that, yes, I want to use a company to own a property, then whatever income derived from that company or from the property may be subjected to the prevailing corporate tax rate, depending on the budget. Every budget, they have some goodies to announce, right? The prevailing corporate tax rate is 17%. LLP, however, is treated as a partnership and not as a separate legal entity for tax purposes. Earlier on, I said that LLP can own a property and be considered as a separate entity. However, for tax purposes, it will not be treated as separate. So take note of that. So hence, the LLP is not subject to corporate tax. Partners are taxed on their share of the profits in accordance with the personal income tax rates. Okay, well, very dry there. Okay. Personal income tax rate can vary. Okay, now I heard it's gone up to 22%. Okay, maybe 17 to 22%. Still considered okay in this region, not very high compared to our European counterparts or in the Western world. All right. Basic comparison. This is another slide that I feel very happy with. Basic comparison between ownership by company, LLP, and personal ownership. So I list down basically a neat comparison. So you can, one look at it, you will know, okay, should I buy it on my own with my friends, use a company, use a partnership, or whatever. Okay. ABSD rates after 12 January. Basically, entities, company, LLP, 15% ABSD, straightforward. PR 10% from second property onwards. Singapore citizens 7 to 10% depending on second, third, or fourth properties that you buy. That's ABSD. Residential, seller stamp duty, up to 16%. That one's quite straightforward. For commercial, no SSD. Industrial. So commercial remains the only play as far as stamp duty is concerned that you don't have to pay ABSD, so on and so forth. For how long, I don't know. Okay. Tax on rental income. For company, if you use a company to own a property, then it may be subject to corporate tax 17%, but entitled to tax rebates of 30% based on the latest budget, subject to a cap of 30,000 in 2015. That may change year to year. LLP, personal tax, staggered based on your income. Okay, take note. So that is the difference between using a company, LLP, or personal ownership. So for those who have bought investment property in Singapore, and you rent it out and collect rental income, you have to declare one in your income tax. Now is the season, right? So don't forget, If they call you and say, how come your rental income never declare, then you may get into trouble. Because all this rental income, you have to declare. But you can, there's some allowance allowed. Mortgage interest, commission payable to agents, all this you can deduct. Okay. GST. If you are GST registered, it's possible to obtain GST, of course, rebate on the purchase from a GST registered seller. For personal purchases, no such thing. Tax on proceeds from sale of property. In Singapore, we have no capital gains tax, therefore no tax on proceeds from sale of property unless deemed to be trading in properties. Okay? Financing. Company, LLP, personal ownership. So quite neat again. So CPF cannot be used. It's quite clear. If you use a company to buy property, you cannot ask the director to use their CPF to buy, right? CPF will not allow. So CPF cannot be used for financing, may entail different borrowing interest rates. Okay, if you use a company, especially a newly incorporated company, there may be some difficulty in getting a loan. all right? Because it's a new company, there's no track record, so on and so forth. Okay? Alternative financing, fundraising options, convertible loans, debentures, crowdfunding, JV. However, if you use a company to buy a property, like I said earlier, you may encounter some problem, some difficulty if you go to the bank and try to obtain financing. But if you use a company to buy a property or use an LLP, there may be other alternative funding solutions. It's a bit creative. You know, I've been sharing a lot of talk seminars with real estate people, investors, so on and so forth. Always trying to find legitimate ways to raise funds, to do joint investments, whether it's in Singapore or overseas. Some of the common options that has been thrown up, fundraising, issued by convertible loans. That means the company actually issue a convertible loans to investors, meaning that for X number of years, if I don't pay you the interest, you can take shares in my company, all right? So the company will be used to buy the property. But of course, in order to do that, they need to raise funds. So what the company does is they issue convertible loans to investors who would then secure the interest and in default, take over the company, take over the shares of the company. That's one way. Of course, you can issue debentures, crowdfunding, or even JV. Get a group of 10 people, we come together or form a JV, fellow shareholders in the company, and we go in together. So if you use a company, these options may be available, right? You can think of something like this. But personal, it's impossible, I would say. You get two fellas, come together and buy. It is difficult to raise funds, okay? Personal ownership entities with no separate legal personality, but CPF can be used, as we all know. So for those who have owned property in your own name, you can use your CPF to pay for it, but only for residential. You cannot use your CPF to buy commercial properties. Insolvency asset protection, there's another difference, okay? Very important. If the property is owned by the company, LLP, it is considered a separate entity, separate legal personality from the director and shareholder. Okay, so the property is shielded, is protected from the shareholder's personal liability exposure. So there are some clients of mine, they actually use company to buy properties. They do not mind paying 18% stamp duty because they are concerned, okay, that if outside there's some exposure, some risk, okay, at least all these assets, all these real estates, they are protected from the creditors. Because strictly speaking, legally speaking, these real estates are owned by the company, not by the shareholder themselves, okay, asset protection. However, if the property is owned by you in your own name, you know, and you own credit card debt and you didn't pay, the bank can seize it, okay? They will sue you bankrupt. Before they sue you bankrupt, what we do is that we see whether you own any asset, real estate. If you own it in your own name, right, we will issue a writ of immovable possession, okay, or possession of immovable properties. Basically, to seize your real estate, sell it, and recover. However, a tip, in Singapore, strangely, if you own the property together with your spouse in joint tenancy, for some strange reason, okay, I shouldn't say strange reason, it's a high court decision, okay? The high court say that the creditors cannot seize, even though the guy is staying in the bungalow. You know, I have a case where the debtor owe my client $100,000. We check, he stay in a bungalow worth about $6 million. I say, well, you know, and he refused to pay. So we wrote to him, I say that, well, if you don't pay up, we are going to seize your bungalow, you know. I mean, after we sell it, you still get $5 million left. But we did a check, we can't even seize. Why? Because the bungalow is jointly owned with his wife. So because of that, he managed to enjoy asset protection based on the simple fact that he is owning the property with his wife. But that is not, to me, a very sexy way of protecting your asset, because please do not forget that your wife may be your biggest creditor, correct? I mean, we are talking on the assumption that the marriage is very nice and rosy, right? So if, let's say, the marriage is on the rocks, you know, when you go for division of asset in a family court, that may be another nightmare, right? So, but in law, at this stage, suffice to know that if you own it with your spouse, joint tenancy, creditors will have difficulty seizing that real estate. But if you own it in your own name, then you may not be able to enjoy that kind of protection. All right? What about tenancy? They will seize that share. The 50% or 40% or 30% they will seize. Joint tenancy, like just now the case I mentioned, joint tenancy. Joint tenancy in law means that the husband owns 100%, the wife owns 100%. There's no demarcation in that the husband owns toilet, the wife owns living room. Both of them own 100%. There's unity in the full ownership of that property. So that's why when we went after the husband, the court said rightly, how are you going to split? The wife also owns 100%. So you cannot seize that bungalow. So basically, we're a very big check. We see that bungalow, he just walk out, and there's nothing you can do. There's the law. But if it's tenancy in common, different story. If the husband only owns 30%, out of 6 million, 30% is still quite a lot. We can, strictly speaking, seize the 30%. But everything is subject to, of course, mortgagee. Bank still come first. So we check the search, right? If there's a mortgage, that means the bank actually owns it, then the bank will come first. Balance one, then you take. Then balance one, the guy take. And then balance, the wife can take. The wife's share will always be shielded because the wife is not a debtor, you see. Right? So to me, that is asset protection in a very unsexy way. Okay? I mean, you use your spouse name, you buy in joint tenancy. Like I say, you buy in joint tenancy, although you may enjoy some form of asset protection, but if you die first, worse, bungalow also don't have really. Because I say, when you die first, your wife, if let's say your wife outlives you, the bungalow belongs to your wife. So in your will, you cannot say, I give my bungalow to my mistress. You can't, because you no longer have the bungalow. So you can't have the cake and eat it, ladies and gentlemen. So you have to think what you want. You have to think fairly long term. Do I want to accept protection? Do I want to prevent my wife from taking? When I die, will I die first? Things like that. Okay, it's not as complicated. Okay, but there are all these implications that you have to consider. All right? Disposal of indirect interest through disposal of shares at valorem duty levy or instrument of share transfer. Another reason why some of my clients considered using a company to own a property is because they think that it's neater to dispose or transfer the property. Right now, I have clients coming to me to say that, okay, I have another 10 minutes. So much information, right? Right now, I have clients coming to me say that I have this property, this condo, I want to give my son, I want to give my wife. Can I add his name, add her name? There's no such thing as adding names, okay? As far as the law is concerned, we are talking about a transfer of the property, either by way of a sale or by way of a present. Yes, you can actually give it as a present, okay? Generally, there are these two ways of adding names, so-called. So if you want to bring your son's name in, bring your daughter's name in, and so on, you are effectively talking about giving your share or giving your house to them. And you can do that by way of selling them or giving to them as a gift. That means $0. Both have their pros and cons, I would say. And this is a common method, as I've shared in other classes. I'm not sure whether you've heard of this thing called decoupling, where husband gives to their wife, or the wife gives to the husband, and you know why they do that. Okay, maybe it's out of love, but most of the time because they have the second property in target. Right? So you can work out the math. I don't have much time to share with you the mechanics. Husband give wife. Let's say joint tenancy, $1 million condo, I give my 500,000 share to the wife. My wife will pay 3%, which is $15,000 stamp duty. That free up the husband. Husband go and buy another $1 million, pay 3%, pays 30,000. Collectively, stamp duty is 45,000. But if they don't do that, husband and wife go and buy the second property, 1 million, they will pay, ladies and gentlemen, 10%, $100,000 stamp duty. So a difference of 55,000. All right? This is just a very basic explanation of why a lot of my clients are coming to me to do some planning. All right? So if you have LLP, personal ownership, or entities with no separate legal personality, of course, usual stamp duty will apply. Like I said, the earlier reason why they do that is because if you own the property using a company, subsequently, if you want to transfer, want to add your son or daughter's name, What you normally do is that you just transfer your share of the company to them. Then indirectly, they own the property, rather than to have to go through the full conveyancing process. Okay? Other considerations, company may act as a family office to manage the family's wealth for asset protection. Like say some wealthy family, they actually set up company to own properties, own shares. They even use this company to hire people like me, lawyer to work in the family office for the well-to-do, for the very wealthy family. So they basically use this company to own everything. And then they will use that company share to give to their descendant. So the descendant who will come in, sit on the board, take over the shares, indirectly own the family wealth. That includes real estate. Okay, however, the cost of doing that can be formidable because you need to hire bookkeeper, lawyers, so on and so forth. Unincorporated associations, quickly, club societies, they cannot hold land in registered name, but only through trustees. There should be at least 2 trustees. If only one, then it should be a trust company. The usual BSD, ABSD, SSD apply. I have clients coming up to me to say, can I use this not to pay ABSD to siam them? I say, you can't. Okay, we have racked our brains for a couple of years now. There is no way. They are very smart, okay, our IRAS people. There is no way to avoid ABSD. The only way is the illegal way, okay, which I will not share, of course, down here. Trust, quickly. Trust can be formed by a trust deed or declaration of trust. That's the document that we sign. So you can use a trust to own a property. A trustee can be your friend, can be your wife, or a licensed trust company, or a law firm even. So a trustee can own your property legally for the benefit of yourself or some other people. Okay, so you involve yourself transferring legal ownership of the property to a trustee to hold it for the benefit of the beneficiary. Okay, sounds a bit deep, right? Very straightforward. You don't buy it in your name. You ask Patrick to buy it. So Patrick becomes your trustee. So the title deed will reflect Patrick as your owner, but I'm holding it as in trust for the benefit of you or your wife. So why do people want to do that, right? Go one round. For a lot of reasons. To protect their asset, because creditors cannot touch if it's not in their name. Okay, so some even do it for sinister reason. They buy it because they don't want their wife to know, or before they get married, they already do that because they know that 10 years down the road, they'll go through a divorce. So they do all this. Some even do trust overseas. So that when eventually the wife really filed divorce, sorry, although I get to use it, but it's not mine, it's Patrick. Right? You go and check. No? Right, so all sorts of funny reasons. Avoidance of family disputes, wealth planning, charitable causes. You can actually use a trust to own a property. Okay, this is a lot of information. You cannot use trust to avoid ABSD because IRAS look at who is the ultimate beneficiary. Okay, so like I say, I'm the legal owner, but IRAS will ask me, who ultimately enjoys the trust asset? If I say that is that guy who owns like 10 properties already, he will still kena ABSD. Okay, they look at the ultimate beneficiary. Rental income subject to trust income tax at 70%, taxable at the trustee level, or B, tax at the beneficiary level as personal income tax. Okay, for resident beneficiaries who are entitled to the trust income. Okay, quite deep. No time to explain. Okay, if you want to find out more about this, you let me know. HDB property cannot be subject matter of a trust. Okay, because that's a HDB law. And using a trust to own a property can be costly. Okay, so before you do that, you have to consider it carefully. Other implications across all property holding structures: restriction of ownership of residential property in Singapore. All Singapore citizens, Singapore company can own property, landed or strata. However, under Section 25 of the RPA, a foreign person, including a PR, including a Singapore company with even 1% of foreign ownership. If you have a company with 1% owned by Bapak from Indonesia, that company is not considered Singapore company. Okay? What happens? If it's not a Singapore company, if you're not a Singapore citizen holding a pink IC, you cannot buy, essentially, landed residential property without the express consent of the Land Dealings Approval Unit. Okay? The approval rate I heard quite low last year. So a foreign person refers to any person who is not a Singapore citizen, Singapore company, Singapore limited partnership, or Singapore society. So take note of this. Do not attempt to hold residential property on trust for foreigners. Just to share with you something, I have clients or I have friends who were actually approached by foreigners with millions of dollars and asked them, can you buy this good class bungalow in Tanglin on their behalf? And of course, my friends are very happy. In their life, they have never owned a good class. And they are very tempted, but I warn them, better not. The last guy who did that went in 9 months jail. Okay? They may say, buy in your name. Because you are Singapore citizen, that is your birthright. You can buy a landed, a good class bungalow. Money I come out, $30 million. Then later, 5 years later, you sell, we split 50-50. Wow, sounds like a perfect game plan, man. Right? Like I said, the last guy who did that went in because they pauto each other. They reported each other to the police because the plan fell through. And that is against the law, so do not do that. Because what you are doing, effectively, you're owning or you're holding the good class bungalow on trust for the foreigner, which is illegal. All right? Conclusion. Some factors to consider when considering which property holding structure: access to finance. So depending on your access to finance, what kind of financing options you want, you decide which structure to use. Okay? Purpose of purchase. Is it for your own stay, investment, succession? Right? So if you want to include your property in your will, then chances are you may want to consider, do you want to own it in joint tenancy or tenancy in common? That is important. If you own it in joint tenancy, chances are if you're 30 years older than your spouse, there's a good chance that you may die first. And if you die first, you no longer own the property. Okay? And for asset protection, preservation, or ease of transfer. So these are some of the factors that you would need to consider before you sign the OTP or SMP. All right? Thank you very much.